Alabama's texting while driving statute, what it is, what it means, and what is unlawful under the statute. The statute section, the code section, is 32-5A-350, and it is entitled Text Messaging While Operating a Motor Vehicle Prohibited. One thing that is very important to understand is this is not a distracted driving statute as has been passed in some other states such as New York, and I think California probably has passed one as well. Under 32-5A-350 section A1, it defines a wireless telecommunication device as follows. Essentially, it says that a handheld cellular telephone qualifies, a text messaging device, a personal digital assistant, standalone computer, or any other similar wireless device that is readily removable from a vehicle and is used to write, send, or read text or data through manual input. The term wireless communication device, essentially from a review of the statute, does not include a device which is voice operated and which allows the user to send or receive a text-based communication without the use of either hand except to activate or deactivate a feature or function. We'll go over in great detail exactly what that means and exactly what is allowed and what is legal and permissible under this statute. Under 32-5A-350 section 2, the definition for write, send, or read a text-based communication is laid out and explained. Using a wireless telecommunication device to manually communicate with any person using text-based communication, including but not limited to communication referred to as a text message, instant message, or electronic mail. The term absolutely does not include reading, selecting, or entering a telephone number or name in a cell or wireless telephone or communication device for the purpose of making a telephone call. So essentially, it strictly prohibits typing out a text message, does not prohibit dictating a text message, and certainly does not prohibit anything related to a telephone call. Under 32-5A-530 section B, it indicates a person may not operate a motor vehicle on a public road, street, or highway in Alabama using a wireless telecommunication device to write, send, or read a text-based communication. Under Section C of the statute, it goes through in C1, 2, and 3 and goes over and outlines the punishment related to this statute and a conviction under the statute. A person who violates the section is subject to a fine as follows. For the first offense, $25. For the second offense, $50. And for the third offense or a subsequent violation is $75. So it's important to note the punishment associated with this statute is very low, and I imagine that this will probably be increased over time. And in addition, this statute will more than likely over time, it'll probably take several years, will be modified and changed into a distracted driving statute, but that is not the way that the statute reads or conduct that the statute prohibits currently. It also notes, which is very important because there are certain violations in Alabama's rules of the road that an officer cannot base a stop of a vehicle solely on a violation. In this statute, it specifically states that law enforcement officers enforcing this section of the statute of the code can use a violation of the texting while driving statute as the sole reason to come into contact with someone or to pull someone over. So it's important, very important to note that, because it can be the sole reason that an officer stops a vehicle and ultimately issues a traffic citation for texting while driving. It goes over further and gives some exceptions to the rule, and it states under Section E, the following uses of wireless communication devices shall not be subject to the penalties set forth in this section. An individual who's using the wireless communication device to obtain emergency services, including but not limited to an emergency call to a law enforcement agency, a healthcare provider, fire department, or other emergency services agencies or entities. Under Section E2, an individual using a wireless communication device while the motor vehicle is parked on the shoulder of the highway, road, or street. This is very important because you can even be cited for a violation of this statute if you are sending a text message, typing it out while sitting at a red light or stop sign or anywhere other than on the shoulder of the road. An individual using a wireless communication device as a global positioning or navigation system to receive driving directions which has been pre-programmed with the desired coordinates. The programming of coordinates while operating a vehicle remains a violation of this section. So if you're using a cell phone as a GPS device, as long as you're not putting in the coordinates while driving, then you are safe to use the GPS device that is on the mobile or wireless communication device. It's important to note under this code section exactly what is prohibited and what is not. The following are illegal while driving: writing a text, reading a text, sending a text, emailing, writing an email, reading an email, or sending an email. Same thing with instant messaging. Writing an instant message, sending it, or reading it is illegal under this section. These are the items which we believe to be legal while driving. Talking on the cell phone is legal under this statute. It's not a violation of this statute. Listening to a text message. Verbally composing a text message. Using a cell phone to look up contacts. Using a cell phone as a GPS. Using the cell phone as a camera. Using a cell phone to listen to music. All of those would be permissible under the statute. A few things to keep in mind as a defendant or someone who is stopped for a possible violation of this statute, the texting while driving statute, is it's important to note that this statute does not allow an officer to take your phone and review your phone. It doesn't allow that type of seizure of a telephone. Because of that, and because there are various items and tasks that you can perform on a cell phone while driving, and it is not in violation of this statute, these are very, very difficult cases for prosecutors to prove under this statute. Obviously, if someone is driving down the road typing a text message, that is very dangerous, and no one should do that. It takes too much concentration, and it takes too much time with your eyes off of the road in order to do that. And therefore, we encourage folks not to type out text messages or emails or read text messages or emails while driving down the road. It's just too dangerous. However, you do need to be aware of certain items and things that you can do while driving down the road so that you are aware and you can operate within the statute to avoid a citation for the statute. Be careful also performing any of the prohibited actions while sitting at a stoplight, a stop sign, or sitting anywhere other than the shoulder of the road. My name's Joseph Kreps. I'm a traffic violation defense attorney in Alabama. If you've been charged with a violation of the texting while driving statute in Alabama, we want to talk to you. Call our office to begin the conversation with us. We'll go over your rights and your options and go over the issues that can be brought up in negotiations to work out your case or to have a trial. Many of these texting while driving cases need to be tried, especially if there are available phone records and other information, or if there are witnesses available who were in the vehicle with you at the time. There should be many trials on these type actions in order to avoid a conviction under the statute if you were taking some action that is perfectly legal under the statute. You can reach us at 866-348-2889. Thank you very much.